You, a potential client, are considering building a building. How do you go about commissioning a design? Well, there are many options available to you. You can discuss your requirements with a builder, ask an architect, or even phone a friend. Inevitably, especially in this financial climate, there'll be a lot of people telling you that they are eminently qualified to design it for you. After all, how hard can it be? A contractor knows how to get things built, and quite often they'll tell you that they'll throw in the design work for free. A colleague may tell you that they can knock up a sketch. An engineer can fine-tune it. A surveyor can cost it. So what does an architect bring to the table? Well, this programme is designed to show you what an architect does, how they add value, and how they help to ensure the successful delivery of a project. So first, what is an architect? Well, in the UK, a person has got to be registered with the Architects Registration Board if they're calling themselves an architect. And you can check this out on their website, shown on the screen now. The letters RIBA after a name, which stands for the Royal Institute of British Architects, designate a chartered architect. So what's the difference between a registered architect and a chartered architect?
The difference between a registered architect and a chartered architect is that a registered architect has to be listed on the register held by the Architects Registration Board. This is important because the term architect is protected by law in the UK and only persons on that register can use that name. A chartered architect is a member of the Royal Institute of British Architects, and they have to satisfy the educational and qualification criteria of that body. This means that they have to have studied for 5 years in a recognised school of architecture and undertaken at least 2 years of practical training. And to remain as a chartered architect, an architect has to undertake 35 hours of continuing professional development each year. A chartered practice is a practice of architects that's a member of the RIBA Chartered Practice Scheme. This is, if you like, an accreditation scheme which is there to provide clients quality assurance about the service they will get from architects' practices. And in order to qualify, a practice has to meet certain criteria. These relate to professional indemnity insurance, the proportion of qualified staff that they have, policies that they've got in place, such as an environmental policy and an employment policy, and also they have to have in place quality management systems that ensure that they manage the project process effectively.
An architect, whether chartered or not, has to perform to a standard expected of a reasonable professional. A chartered architect is governed more directly by a code of professional conduct. Amongst other things, that code insists that an architect be impartial, responsible and truthful. He or she must not pretend to have expertise or resources that they do not have. And they must be fair in their dealings with others. Now, one aspect of this fairness or impartiality means that during the course of construction, an architect should not be biased towards the client, but be fair in representing the contractor's concerns as well. An architect employed as a client's agent is another matter, where he or she is employed directly to represent your interests, and we'll explain that in a moment. Now, all of these terms and many more relating to contracts, approvals, job titles are explained in our programme JCT Contract Terms Explained. One requirement of the professional code is that the architect should agree with you and record the actual amount, type and level of work to be carried out. Indeed, in March 2010, an architect was sued for not making his terms and conditions explicit.
The RIBA has a range of appointments which are agreements between architects and their clients, and they're very specific for sorts of work, and you just pick the one that is best for you and your client. As an architect, you could look at a domestic form, and that's if you've obviously got a domestic client, or if you have a small commercial project, there's a concise form, which is appropriate. For larger projects, particularly for business clients, you'd use the RIBA standard form of contract.
Be aware that an architect retains the copyright of his or her design, although you, the client, are allowed to use it for the benefit of the project. During the course of the works, the architect is obliged to keep you informed of progress, cost implications and quality issues, although bear in mind that problems affecting these three may not become apparent for some time.
There are many factors which affect cost, time and quality in a construction project. To many extents, each construction project is unique. It's almost a prototype. It's a complex process. So there are a number of things that may not be apparent at the outset. The sort of things that can affect cost and time are perhaps unforeseen circumstances in the ground. Any changes that the client brings about during the process can affect the timescale. There may be other parties involved, such as electricity and gas suppliers, and their timetabling of their works may affect the progress of the project. Then there are factors that come into play during the construction phase. There may, for example, be exceptionally inclement weather which could not have been foreseen, and that may result in a delay. So for these reasons, it's often difficult to predict with great accuracy the length and cost of a project. There are a number of different insurances that an architect really ought to carry. The first and most important, and one which they must carry, is professional indemnity insurance. Many architects will also carry public liability insurance, and often perhaps also employers' liability insurance. Professional indemnity insurance is there to protect both the architect and the client for the architect's liability in the project. Its primary purpose is to ensure that if there is any professional negligence on the part of the architect, that any costs that are incurred as a result of that are covered by an appropriate insurance policy. Public liability insurance is a form of third-party insurance. It covers any accidents or damage that may occur to an individual on the premises of the architect, and it also covers the architect's staff for any damage they may cause to the client or the contractor's property when they're making site visits.
Remember too that you, the client, have obligations when appointing an architect.
The client has a range of duties under the appointment, and it's very important that he fulfills his role as well as the architect fulfilling their role. The client has to, for example, make sure that they give all the information to the architect, legal responsibilities, anything particularly regarding the site. They have to appoint the consultants, including the architect. They have to pay them when their appointment terms require. They have to take an appointment with other consultants separate from the architects. They also have to have a contract which is separate from those appointments with the builder and make sure that they pay the builder. And perhaps most importantly, they have to make sure that they issue information and approve documents when the architect and the team require them to be done. Under the Construction Design Management Regulations 2007, everybody that's involved in a building project has a duty to take care for health and safety. And it's not just the health and safety of the building construction. There's requirements under demolition, there are requirements to maintain the building, etc. So everybody has a part to play, including the client. Certain projects are notifiable projects to Health and Safety Executive, and within that area, the client has a responsibility to appoint what's called a CDM coordinator. That's a Construction Design Management Coordinator, and to make sure that there's sufficient resources for the project, and particularly to make sure that they have appointed the right people for the project. There is, within a domestic form, a much smaller requirement, but for all projects, clients have to make sure that they are appointing the right people for the project and that it's properly resourced.
The plan of work is a breakdown of the stages of the project, from the initial brief, through the design development and up to the completion and final evaluation of the scheme. These are covered by the architect's appointment. So let's take a look at some of the stages in more detail. First of all, we'll examine what are called work stages A to D.
Work stage A is where the architect is trying to find out all the client's requirements, what kind of accommodation they need to provide, how big the spaces need to be, but also their aspirations for the timescale for the project and their parameters in broad terms on cost. Work stage B is where the architect takes the information they've obtained in work stage A, which may have included some feasibility studies to look at different options analysis, and from this they develop the detailed brief. This will include the accommodation schedule and all the requirements in terms of procurement methodology and constraints such as cost and time. A well-developed brief should really equip the architect with all the information he or she needs to successfully deliver the project. This should represent all the client's aspirations and also reflect the constraints upon the programme. Although distinct, work stages A and B together form what we call the preparation phase. And this is typically done on a time charge basis because at this stage the definition of the project is only just being formed.
Stages C and D are quite specific and quite different within the architect's appointment. They do follow on very specifically one from the other. Stage C starts when you've got the right brief, and it's absolutely vital that you do have a proper brief before an architect starts work for you. And then the architect will take that brief and develop initial concept designs and perhaps outline costings and specification, which require your approval before they can then go on to the next stage of developing the design to the point where an application is ready to go in for planning permission. Normally, designs do develop after stage D. As one is considering the details of the project, it's very normal for clients to make small changes to the design, and the designers, in fact, themselves might suggest small changes. But major changes of design after planning permission has been granted cause enormous difficulties. For example, you may have to go back and reapply for planning consent, and that has enormous time and cost implications. So it's much better to finish the design and sign it off at the end of stage D and go on to design development into the detailed design, which really are the minutiae of the construction details.
Stage E is the technical design, where the drawings and associated documents are worked up into greater technical detail. Stage F is where the information is produced sufficient to submit the scheme in for building regulations approval. Note that the architect should not guarantee that the scheme will gain approvals, as this is obviously outside his or her control. Stage G, the preparation of information prior to sending out to contractors. Stage H is where contractors are chosen, assess the information and submit a price. J is choosing and appointing the contractor, and stage K covers the administration of the work on site. Then stage L is the completion of all the documentation, including the final inspections and operating and maintenance manuals. Now, you may not need the architect to perform all of these stages, so you have to be clear at the outset the range and limits of his or her involvement. Project management is about leadership. Simple projects you may be able to manage yourself, but for more complex designs and situations, the architect's role is to steer the scheme.
Architects have a unique education. Obviously, they're very, very highly skilled in design, but they're also taught information that enables them to manage construction processes from inception through to completion. This gives them a special overview of the process which perhaps the other players within the construction process do not bring, because they tend to specialise in one particular area. The client does need to be aware that an architect does need sufficient resources to complete the project. I think what the client needs to address is there are really two things we're talking about here. One is resources in terms of expertise. There may be certain specialist skills that are required, such as conservation expertise or knowledge about a specific building type, and the architect either needs to have that expertise in-house or be able to access it through a second consultant. The architect also needs to have sufficient staffing resources to complete the project. So this means that you need to be sure that your architect has sufficient staff with appropriate levels of seniority to deliver the programme which you intend to complete.
In broad terms, an architect can play several other roles. The project manager. This is what it says on the tin. He or she manages the project to ensure that, as far as possible, the scheme meets the programme cost and quality requirements. The lead consultant. The lead consultant is at the head of the team to coordinate and prepare programmes and report on progress. The lead designer coordinates design work by specialists and suppliers and liaises with you, the client, to discuss the issues arising. And the contract administrator, or employer's agent, who invites and assesses tenders, administers the contract, reports on progress and signs off payments. Now, usually an architect, contract administrator or employer's agent is empowered to issue instructions that can vary the work being carried out. Variations, and that means altering the original design, may have cost and time implications. The architect should get the client's approval before issuing such instructions, but the client should be aware that in some instances this may not be possible. Similarly, asking the client to confirm each and every variation in writing might impose unreasonable demands on the contractor. The cost of delaying a job while waiting for a reply may have bigger financial implications than the variation itself. Either way, the architect must be able to substantiate cost variations. You're at liberty to negotiate with your architect, but the fee will inevitably reflect the complexity of the project. Remember too, that if you agree a percentage fee for the job, it'll normally be a percentage of the finished costs, not of the cost estimate.
The architect has to take into consideration a number of factors when they're actually putting a bid to the client. Most important, of course, is the client's requirements, and they need to make sure that they understand what those requirements are, and they can involve how long the project should take, how much they want to spend, i.e. how much the budget is, and the constraints and opportunities within that project for developing the project. They then need to consider those while they're then thinking of the resources that they need to put into the project and make sure that they've costed for that when they put their bid into the client. I think it's very important that clients don't just choose an architect by the size of their fee. What they're really looking for is the best person for the job, because that person will bring the greatest value and the greatest benefit to the project. An architect's fee is a small percentage of the construction cost. So what you should be looking for as a client is the right person with the right expertise and resources, and perhaps the right locality and local knowledge to be able to carry your project out to its absolute best and hit exactly what you're after as a client. Don't necessarily choose on cost, choose them because they're the best person for the job. There's a lot of guidance on different stages, but actually it's very much down to the project and the architect and the team to decide how you want to split the various different elements of the project. If you have, for example, got a fee which is a lump sum fee for each stage, it'll be very clear what the breakdown is and it'll reflect the project. But if you're on a percentage fee which takes you across the whole project, normally you'd expect to pay something like 30% of the fee at the initial stage to take you to planning, about another 30% to take you up to tender, and the remaining fee will take you through the construction stages if your architect is going to be your contract administrator.
Usually the fee structure is based on a percentage, a lump sum, or on time charges like hourly rates or something along those lines.
Lump sums offer an advantage to the client in that they give cost certainty. You know at the outset what the architect is going to charge, and this is fixed. And provided you don't introduce changes to the project at a late stage, you will get that as the fee outcome at the end of the day. The disadvantage to the architect of the lump sum fee is, of course, that they're having to price in some risk because they cannot be certain as to the number of hours that it's going to take to complete the project, and therefore this may be reflected in their lump sum price. The benefits of a time charge fee basis are that the architect is being paid for every hour that they put into the project, and therefore the client can guarantee that the resources will be available to complete the work. The pitfalls are that this gives less cost certainty because it relates to the number of chargeable hours rather than a fixed cost. Time charges may be appropriate, for example, in very specific circumstances if your architect is going to be involved in site inspection and it's not clear how much work that will involve. A time charge basis may be very good for both client and architect. And particularly in the early phases of a project where it may not be certain whether a project is going to continue or not and it's simply feasibility assessment, again a time charge basis may be very appropriate. The client does have a responsibility to pay the architect in a timely basis. The RIBA, for example, produces a number of standard appointment agreements, and payment terms in those contracts normally vary from 14 to 28 days.
Now, this programme has outlined what is often called the traditional method of procuring a building. That is, appointing an architect to design the building, draw up the tender list and invite contractors to bid, and overseeing the work on site. But one less traditional but quite common other method is design and build. Now here you appoint a contractor directly and pay your architect up to that point. It's then that the contractor takes over responsibility to deliver your project. The contractor may want to appoint the same architect to continue providing detailed information, in which case the architect ceases to work for you. But you may want to retain the architect as an advisor, in which case the contractual relationship remains, but often at a much reduced involvement.
In design and build contracts, the relationship between the architect and the client changes if the client decides that they want to keep the architect as their personal advisor. It's a very different role from the standard and traditional forms where the architect is in charge all the way through. In a design and build contract, at a certain point, design responsibility is handed over to the contractor, so the architect's role will be one of advisor to the client. Novation is a way in which the architect moves client, and it's a most unusual situation. Although it's commonplace, the architect has a different role. They become contracted to the builder, whereas to start with, they are contracted to the client. They effectively move clients at a certain point during the course of the contract. This changes the relationship between the architect and their first client, who is the employer for the project, and their client then becomes the builder. And not unnaturally, there can be conflicts of interest.
The key thing in the appointment of an architect is that you ought to be reasonably assured of a professional and considered approach to your requirements. Because of their training, an architect ought to be able to give you insights into some of the design opportunities that maybe even you hadn't realised. However, you've got to be clear about the design parameters, especially if budgets are tight. One more thing about architects. Unlike other design professionals, they must undertake 35 hours of continual professional development every year to make sure that they're up to speed on the ever-changing world of technical regulations. In this way, the RIBA hope to ensure that your experience of employing an architect is mutually beneficial.
The architect must set out in the appointment agreement or letter of appointment very clearly the complaints procedure if something goes wrong on the project and the client wishes to make a complaint. And the architect must address any complaints in a timely manner. The appointment agreement will also then generally set out the methodology that's going to be used if we get into a more serious dispute. One of the preferred methods might be mediation, because obviously if you can bring the parties around the table and agree a resolution of the complaint, this may be more satisfactory. But for more serious issues, it may be necessary to use, say, the adjudication provision, where an independent tribunal will determine the matter. This is the way in which the legal aspects of a complaint may be dealt with, but of course the architect has obligations under the Code of Conduct, both the ARB Code of Conduct and the RIBA Code of Conduct, and if a client feels that an architect has not discharged his obligations under those codes, they may of course make reference to those two bodies to have that looked into. The appointment agreement should make clear what the legal processes for dispute resolution are. It's also important that the architect makes clear in the initial appointment letter or agreement that he or she is subject to the ARB code and must make the client aware of where the information about the Code of Conduct can be found and where the complaints procedures can be found.
So there you have it, a brief synopsis of the roles and responsibilities of the architect. Our thanks to Adrian Dobson, the RIBA's Director of Practice, and Jane Duncan, Vice President of Practice at the RIBA, for their insights. For further information about employing an architect, please take a look on the RIBA's website on your screen now. Good luck and goodbye.